This is an important day for the state of South Carolina as they're getting ready to be resting their case in chief. And before they do that, they want to try to get in some more bad evidence about Alex Murdaugh. That roadside shooting incident that went awry with cousin Eddie resulted in charges for both of them. Well, they want to offer it for a limited purpose here. And we talked in our last hour about how this is a stretch. This might be far too attenuated to come in, but they're trying, and the defense is pushing back hard. We're going to go back in now where we left off. You'll see some more arguments from the attorneys and then the judge's decision.
I would concede he's correct. Once he realizes he's still alive, he tells that story. But obviously, he didn't intend to be still alive. In other words, it's not a scheme that was concocted at any point. The scheme, if it's a scheme, was concocted after he realized he wasn't dead.
Well, the financial evidence was allowed on the issue of motive. This evidence, I find, goes beyond motive, or is not evidence of motive, but more toward common scheme or plan. It does not survive the logical relevancy test, and it goes more toward showing the propensity to commit violent acts, which would cause it not to survive the 403 analysis. I believe that to allow this evidence is a bridge too far, going down this path of allowing essentially any and all evidence in. We have guardrails. The court is to place guardrails to keep things within a reasonable realm. And I believe this, as I stated, will be a bridge too far. It does not meet the logical relevancy test. I agree with the defense that it would be admissible, perhaps, if the trial was a trial on the financial theft issues, but not on the murder. So I grant the motion to exclude this evidence at this time. Of course, as we have seen, things change. And who knows?
Understood, Your Honor.
All right. Did we tell the jurors 10 or 10:30?
I think we said 10:30, Your Honor.
10:30. Okay.
I said 10. Mr. Waters said 10:30. So if there's any acrimony here, please focus it where it belongs.
Well, I routinely underestimate the time, so the one time I overestimated.
Well, we tested the jurors this morning, and happy to say that they all tested negative, so we're in good shape with the jury. All right. Any other matters we need to discuss during this light time?
Yes, I just think Mr. Waters and I were talking extensively about when he's going to rest his case. We think that should be, or he thinks that should be, he thinks tomorrow morning. I'm projecting maybe tomorrow afternoon, but on Friday we expect to start our case. And to that end, if something were to happen between now and Friday morning, we are flying in experts, and don't need to tell Your Honor how expensive that process is. So even if they don't finish, we may ask the court to allow our witness. It's a footwear expert. It's not anything of explosive. But if he's here and they can't finish by Friday afternoon, we'd be asked the court at that time to allow him to testify out of order, simply to save thousands of dollars, have him have to come back the following Tuesday. And I haven't asked Mr. Waters about that, but I want to put it on the record.
I'm certainly going to be within reason accommodating to the defense and things like that.
Great. I just thought I ought to mention it so it doesn't look like a surprise to the court. Thank you, Your Honor.
All right. Anything else then?
Stand by, Your Honor. Excuse me, please.
While they're talking, I have something to say. I've said it before on the show. I'm going to say it again. The Honorable Clifton Newman knows his stuff. He knows the rules of evidence. He knows how to run a trial.
For about 15, 20, or 30 minutes, or 37 minutes.
And we're a little behind on the tape. So 10:30 a.m. Eastern should be the start time. But a ruling from him that was spot on with the rules of evidence. This was quite a stretch, and I think the state would probably admit that, trying to get this evidence in about the roadside shooting. And the judge gave a very well-reasoned rationale for his decision and why it shouldn't come in. You can't have what's called propensity evidence coming in. I like to use the example, once a thief, always a thief. Or here he's saying, once violent, always violent. It can't be used in that regard. It's got to be a lot more specific. And here he's saying they're lacking specificity and even and even going so far to say is they're lacking relevancy. He said they're not even passing the relevancy test with this roadside shooting case. So the court not letting that in. Brilliant judge here who's done a tremendous job running this trial. Now, I want to bring in my guest because he's got some really interesting perspective about how this actually probably did the state of South Carolina a favor in a weird way with this ruling that was a defense victory. Attorney Brian Silber on the show this morning. Brian served as a prosecutor. He does criminal defense work now in the private sector. He's based in Fort Lauderdale. And earlier, Brian, if you told us how you said, I don't know why the state is trying to get this in. This isn't going to be helpful. Would you kind of share your thoughts on that and then what this has done now in confining their case?
So in my experience, there really are two types of prosecutors. There's the kind of prosecutor that wants to win, and then there's the kind of prosecutor that is really seeking the correct outcome, whatever that is in the case. And, this is the human element of trial work. In his drive to win, he's trying to put anything in that he perceives will help him. But in my perspective, I think the judge did him a favor because the defense would have just pounced on them. The fact that this guy tried to have someone else kill him for insurance money to go to the Sun really doesn't speak to anything that happened on the evening of these murders. And not to mention the fact it makes no sense. No one is going to have another person shoot them in the head to make themselves look like a victim to get out of trouble. And the main reason is you'd probably die. And if you don't die, you'd be completely disabled. He got lucky that the guy missed. But the whole thing doesn't make sense. It's completely irrelevant. It's a total distraction. And I really do think the judge did the prosecution a big favor because it would have been really bad for them to sustain the counterattack that surely was coming.